If you've been injured in a car wreck, we want to help you. Call Lanier Law Group. Every day we go toe-to-toe against insurance companies fighting for the rights of accident victims. Hire a heavyweight. Call 1-888-CONSULT.
If you're injured in an automobile accident, there are many different types of insurance that may come into play. You may have medical payments coverage on your vehicle, on your policy, or in the vehicle that you were riding in. You may also use your health insurance to pay for your medical bills. If the at-fault driver carried inadequate insurance or no insurance, you may be able to use uninsured or underinsured motorist coverage from your own policy or a family member's policy. You can also look to the vehicle that you were riding in for uninsured and underinsured. And in North Carolina, your rates will not go up because you make a claim against your uninsured or your underinsured. There's no fault assessment for making a claim against your uninsured or underinsured. If you were not at fault in the accident, your rates should not go up. If you were on the job at the time of the automobile accident, you may collect your workers' compensation benefits while simultaneously pursuing the automobile coverage. You may use your health insurance to pay your medical bills related to an automobile accident. Even if you have Medicare, Medicaid, or Champus, or TRICARE, you may be able to file your accident-related medical bills on your health insurance. If you don't file your medical bills on your health insurance, then those bills may have to be paid out of your recovery, whether it's a settlement or verdict. But if you use your health insurance, a new law that went into effect in October of 2011 has an implication on how those medical bills may be treated by the insurance company or by a jury. If you have filed those bills on your health insurance, then the amount of money that the insurance company or a jury may consider as damages may be reduced to the amount that was actually paid by your health insurance. If you use your health insurance, you may receive a notification in the mail that your health insurance is claiming subrogation rights. Subrogation means that your health insurance is seeking to be repaid for money that they paid on accident-related bills. Just because you receive that notification doesn't necessarily mean that there's a valid subrogation claim. We would need to take a look at the specific plan language in order to determine if there was a valid subrogation interest. And even if there is a valid subrogation interest, we have great success at negotiating a reduction in that amount. Even if you have to repay your health insurance, it usually ends up being significantly less than if you had to pay those medical bills out of your recovery. There are many types of compensation you may be entitled to when you've been in an automobile accident. Payment of your medical bills, pain and suffering, any kind of permanent physical injury or scarring, as well as time missed from work, mileage. You may be entitled to punitive damages if you were hit by a drunk driver or someone who was driving willfully, carelessly, recklessly, with intentional disregard for your safety. The insurance company may be required to pay your property damage, which may include the total loss of your vehicle. It may include the repair of your vehicle if it's not a total loss, and it may include a rental car for the replacement of your vehicle while the repairs are being made. If the at-fault driver failed to carry insurance or failed to carry adequate insurance, you may need to look to uninsured or underinsured motorist coverage. At Lanier Law Group, we work on a contingent fee basis. That means that you don't owe us any attorney's fee unless and until you obtain a recovery. Our attorney's fees are a percentage of the recovery that we obtain for you. There are no circumstances whatsoever in which you will ever owe us money unless you recover.
Many people call and ask us if they are required to give a recorded interview to the insurance company. We advise our clients not to. There is one exception. If your claim is an under or uninsured policy claim, you are required to cooperate with your insurance company, which may include giving a recorded statement. If we represent you, we of course want to be present for any recorded statement that you would ever give. Is there a time limit for filing a claim? Yes, there is. In North Carolina, the law requires that if you haven't settled your claim within 3 years of the date of incident, that you file a lawsuit. If you don't do so, your claim will be lost forever. In the event of death, the law requires that a lawsuit be filed within 2 years of the date of death. Can you settle your property damage claim without also settling your personal injury or bodily injury claim? The answer to that frequently asked question is yes, you can. It is important that you're careful when you do settle your property damage claim that you not at the same time sign away your rights to your bodily injury claim. How much will the insurance company pay for pain and suffering? There is no set formula, but the amount that you receive for pain and suffering is tied to the degree and severity of your injuries, the amount and kind of medical treatment that you receive, and several other factors that we can talk to you about. Do you have to go to court? The vast majority of personal injury claims in North Carolina settle before there's ever a trial. As long as we are able to help you get the insurance company to pay a reasonable amount for your injuries, your claim can settle without ever going to court or even without a lawsuit being filed. However, in cases where the insurance company does not pay a fair amount, we have the resources and the wherewithal to file lawsuits and take your case all the way to a jury trial.
When it's your health, your time, and your money at stake, call Lanier Law Group. Hire a heavyweight. Call us today at 1-888-CONSULT.